It's great to see a very good attendance from across Australia, looking at the attendance as people from a range of industries across all parts of Australia. This is the Appian briefing on what we'd probably best refer to as the Industrial Relations Omnibus Bill, or amendments to the Fair Work Act. So the full name is there. So my name is John McKenzie. I'm Associate Director with Appian based in Sydney, and welcome to the webinar. So what we're going to cover today is the review of the Fair Work Act and the consultation which had taken place last year, casual provisions that were retained, and you might have read over the last couple of weeks that the bill has been significantly amended and passed with a lot smaller provisions. So what was not included, it's worth, I think, covering. And then as a result of some of those amendments and as a result of what's included in the bill, there is some matters for employers to attend to, which we'll cover as well. So firstly, the review of the Fair Work Act and the passage of the bill. If you've been following it from about middle of last year, the federal government set up working parties with unions and employers to look at a number of aspects of industrial relations law, looking at and discussing with those parties about making changes. Those discussions concluded around September last year, and the bill was the Fair Work Amendment Supporting Australian Jobs and Economic Recovery Bill was introduced into Parliament in December 2020. Now, it was passed by the lower house, and then, of course, as we know, under Australian law and federal law, that legislation has to be reviewed by the Senate. So that's where the bill tripped up. Labor and the Greens basically said that they were going to oppose the entire bill. There were discussions that left the minor parties, which essentially were One Nation and a couple of crossbench senators. So discussions were held with those minor parties and crossbench senators, and the bill was significantly amended and a number of provisions removed. The bill was passed by the Senate the last sitting Senate day before the May budget, so it was obviously time pressures on the government to resolve the IR omnibus bill before the budget, and it was passed by the House of Reps last week. So what did it mean? Well, there's essentially what changes are left result in amendments to the Fair Work Act, and specifically around casuals. So the casual provision is probably the most significant thing. The bill retained casual definitions as originally proposed. And as a result of that, dealt with the uncertainties and inconsistencies surrounding the casual employment, which followed Workpac and Skene and Workpac Mazzotti cases. If you've been following those, you will recall that essentially there's a number of two decisions there which caused great uncertainty for employers, and consequently there's a risk of inadvertent underpayment and double dipping are also addressed. So if you recall Workpac and Skene, Mr. Skene was employed as a casual on a fly-in, fly-out basis. He was rostered for a year in advance. He worked effectively pretty much every shift for about 2 years, with the exception of a 7-day break, and was paid a flat hourly rate. He was terminated and sought annual leave following the termination of his employment. The matter went to the federal court and then full federal court on appeal. The court applied the common law definition of a casual and found that the employee was essentially a permanent employee and entitled to annual leave, and for that matter, other leave entitlements. On appeal, the full court determined examined the entire nature of the employment relationship, which, in other words, applied the common law definition rather than rely on the employer's designation of the employee as a casual. And up until now, most employers have relied on the essentially simple definition of a casual as one engaged and paid as such. there were common law cases around concerning long-term casuals, but what Skene did essentially is overturn that and cause great uncertainty for employers in terms of how they employ casuals. Workpac followed that decision with essentially a case which it ran in the federal court subsequent to Skene with concerning Mr. Rosato. Mr. Rosato was employed on 6 consecutive employment contracts over a 4-year period up until 2018. His employment ended and he claimed entitlement under the Fair Work Act with respect to annual leave, paid personal carers leave, and payment for public holidays. Workpac argued in that case that Mr. Rosato was a casual on the basis of an absence of a firm advance commitment as to the duration of the employee's employment of the day or the days and the hours the employee will work. So they argued also in that the presence of or absence of such a commitment was to be determined by reference to the party's written contract of employment and without reference to other materials, including evidence on the way in which the conduct was performed in practice. All this is significant because it comes to how the bill is constructed. However, despite Workpac's submissions, Mr. Rosato was held to be a permanent employee and entitled to leave and other entitlements. The court found that the parties had agreed on employment of indefinite duration. It was stable, regular, and predictable, and there was firm advance commitment that was evident in each of his 6 contracts, Mr. Rosato's contracts. And the presence or absence of a firm advance commitment may be assessed by regard to the employment contract as a whole. So that's an important finding of the federal court. They also found that the description given by the parties as to the nature of their relationship is relevant, but not a conclusive consideration. So again, going back to what employers had relied on for many years was the definition of a casual was one engaged and paid as such a gain that essential definition was again turned over. So an addendum to that was that Workpac could not rely on the payment of the casual loading to offset any liabilities against entitlements under the Fair Work Act for leave and public holidays. So they found that the regulation could only apply where a person makes a claim to be paid an amount in lieu of one or more of the NES entitlements. Mr. Rosato, they said, sought payment of the NES entitlements, not payments in lieu. So it was a technicality in relation to how the offsetting arises, but certainly the federal court have found against Workpac there. Workpac has appealed this matter to the High Court, but we haven't got hearing dates yet. They've got to be determined. So what does the bill outline? Well, the bill outlines for the first time a definition of casual. So it's a new provision. And then there's provisions in the legislation which change casual conversion provisions, which effectively create more onus or greater onus on employers in addition to the current award arrangements. So Ashley Lynch is helping me here from our Brisbane office. We're going to just do a quick survey. We've got 2 questions which are different. So the first question is, in your employment of casual employees, are casuals paid an all-up rate? We're just looking at how casuals are paid, whether in fact there's simply an all-up rate paid for casuals or not. And the second to that is whether casuals are paid a loading as an identified amount, whether it's an all-up rate or not. So I'm just looking at the extent to which casuals are paid an all-up rate, and then the second piece is whether the casual loading is paid as an identified amount, which is separate. Which is the relevance of these will be evident as we go through the rest of the presentation. So you'll have probably 10 or 15 seconds to answer those questions. If you could submit those answers. She'll be able to enter there. So how are we going, Ashley? Oh, so poll was closed. So do we have the stats? Okay, right. So significant number of casuals are paid an all-up rate, which is interesting. So significance of that will come through as we go through the presentation, and then casuals. There's probably about two-thirds, one-third there, and in terms of whether the casual is paid as a loading as an identified amount, well, almost in between two-thirds and three-quarters are paid as an identified amount. The answer is no. So we'll deal with those that don't pay the casual loading as identified amount as well. So that's a good understanding. We'll go through those issues in the rest of the presentation. Okay. Right. So the new casual definition in the Act provides that the offer and acceptance of employment made by the employer is made on the basis that there's no firm advance commitment to continuing and indefinite work. So that's important, significant. So in other words, you're employing someone as a casual. The offer of that is you are a casual. There's no firm advance commitment to work. That's agreed on that basis by the employee, and that's essentially how the employment's set up. Regardless, a regular pattern of hours does not itself indicate a firm advance commitment to continuing and indefinite work or an agreed pattern of work. So you might be working regular hours or regular pattern of hours, but that doesn't mean that that's an firm advance commitment to work. So the question whether an employee is a casual is assessed on the basis of the offer of employment and the acceptance of that offer, not on the basis of any subsequent conduct of the party, which is also significant. So you might start as a casual and the conduct of the parties might change. And that's important when it comes to dealing with offsetting, which we'll cover shortly. So what is no firm advance commitment of work? Well, in determining whether at the time the offer is made, there's no firm advance commitment to continuing an indefinite work. Regard must only be had to the following considerations. So that's what the legislation says, only these things. The employer can elect to offer work and the person can elect to accept or reject the work. So that's obviously a typical casual arrangement. The person will work only as required. The person's employment is described as a casual. That goes without saying, but it's important consideration, and very importantly also that the person will be entitled to a casual loading or a specific rate of pay for casual employees under the terms of the offer or an instrument. So those four things determine what no firm advance commitment of work actually means. So whether the person can whether the employer can offer or work, and whether the person can accept or reject it, whether the person can only work as required, the employment is described as a casual arrangement, and the person is paid a casual loading. So offsetting casual loading is also dealt with in the legislation. So you recall that was dealt with in the Rosato case. So the bill provides employers with a mechanism to use casual loading to offset relevant entitlements. So they may be such as annual leave, personal leave, holidays, notice and redundancy. That's where a court finds that a casual employee, whether former, current or new, in other words, taking into account the retrospective nature of some of this, does not meet the statutory definition of a casual. So that offsetting is available where an employee is paid an identified casual loading to compensate the employee for not having one or more entitlements. So that's significant when we dealt with the survey. Those respondents to that particular question should look at this very carefully. So in terms of the statutory definition concerning this, the statutory definition is to be applied retrospectively. So that means that former and current casual employees who meet this definition at the commencement of their engagement cannot later claim leave entitlements, even if their employment status has changed due to the post-contractual conduct. So very important provisions here which deal with the employment of casuals clear a lot of uncertainty up concerning potential liabilities. But there's, I think, as we've seen from the questionnaire, some work to do for employers, which we'll come to shortly. So in addition to the matters dealing with the definition of casual and also offsetting, there's a third provision which deals with the right to conversion, which place more onus on employers. So, so an eligible casual employee has a expanded right to conversion, to convert after 12 months, where during at least the last 6 months of that 12 months, the employer has worked a regular pattern of hours on an ongoing basis without significant adjustment. And the employee could continue to work as either a full-time or part-time employee, as the case may be. So what does conversion mean? If you meet that test and you've got to offer it and the employee accepts it, then if working the equivalent of full-time hours, the offer is to a full-time employment. So that's the first point. The second point is that if the employer is working less than full-time hours, the offer of part-time employment is consistent with the regular pattern of hours during that period. So you make an assessment as to what the employee, if they were not working 38 hours a week, for example, what the employee's regular pattern of hours are during the period. And the right to conversion also applies to award and agreement-free employees. It's not just award covered. So what are some of the processes? Well, if the employee meets the tests, then you've got to make the written offer of conversion, unless there's reasonable grounds not to do so. So that is essentially based on an assessment of the employee's ongoing employment and hours of work. For example, if an employee's regular hours will cease due to a completion of a project, or the fact that the work is winding down, you know that that particular work which the employee is working on is going to be converted to somewhere else. For example, they're just some examples. In other words, you make an assessment as to whether the employee's ongoing employment hours of work will continue, and that's essentially a basis upon which you would say that there's no reasonable grounds. The requirement for the employer to outline reasons in writing why the employee is not offered a conversion. So not only do you have to write to them to say that there's an offer of conversion, you actually essentially got to put to them as to why there's no offer of conversion. Now, if you do nothing, which is what some employers may do from a whole range of reasons, then the employee has a residual right. So the residual right to request conversion where the employer has either not refused an offer of conversion, has either not refused an offer of conversion or has not been advised why the conversion was not offered. So if you do nothing, there's still a right of conversion where the employee's hours and pattern of work actually meet the test. Existing eligible casual employees may request conversion within 6 months of the legislation commencing if they have been employed on a casual basis for at least 12 months. And where there's disputes about conversion, then the Fair Work Commission can deal with the disputes under this section. In addition to this, there is a requirement to establish for employers to give a casual employment information statement. Fair Work Ombudsman is required to publish that. That has to be provided to casuals by employers as soon as practicable after the casual starts employment as a casual employee, and not required to provide the statement for more than once a year. Now, for those existing casuals, my advice will be to once the casual employment information statement is published, then employers should provide that to existing casuals. But as I said, not more than once a year. And this is bearing in mind that even these changes to the legislation concerning casuals are very contentious with particularly Labor and the unions. You recall if you followed it up to the time of the legislation being considered in the Senate, certainly this whole insecure work debate has arisen, and the ACTU Secretary, Sarah McManus, has recently described insecure work to include not only casual workers but also part-time employees that want more hours. So which is a significant departure from the whole insecure work debate. And then, of course, Labor have indicated that their intention to expand the definition of employee to include gig worker. Now, if you look at the stats on gig workers, in terms of numbers, there's, I think, some reports, media reports, say that there's up to 8% of workers in some states, which I don't think there's any real grounds to establish that. I think it's more likely that gig workers will be probably represent less than 1% of the workforce. So, we're talking about Airtasker, Uber Eats, and so on. So they're looking at, the Labor leader is looking at applying a portable leave benefits for casuals, applying the same job, same pay for labour hire casual employees, and restricting the duration of fixed-term contracts for casuals, labour hire, particularly, in this case, labour hire as well, to 2 terms or 2 years. So what are the facts? Just in this casual debate, because it is, again, a contentious issue, and if you're bargaining, it's likely to come up in bargaining. The employment numbers are probably back around where they were in February last year, just over 13 million. Full-time and part-time employment is split roughly 2/3, 1/3. What is a casual? A casual is defined, and which is the whole debate. Casual is defined by the ABS as those without leave entitlements. That's something which is genuinely accepted. Now, the casual workforce really hasn't changed much over the last number of years, and there has been some reduction, obviously, given the impact of the pandemic last year. And as you saw, there was significant number of casuals that weren't entitled to JobKeeper, and a number that were. The estimates were that were probably roughly 40% of the casual pool of these that weren't entitled to JobKeeper. So that's a significant number. So there's certainly reduction in casuals. You're looking at the casual numbers at around 2.3 million workers in the workforce as at February this year. In addition to that, there's around 1 million independent contractors. So there's about 8% of employed workers. Now, the underutilisation rate, which is a combination of unemployment and underemployment, is around 14.4%. And there are stats from the ABS which basically lead the fact that part-time workers, many part-time workers are looking for more hours. So there's a number there. So the ACT does have, there are some supporting arguments around the underutilisation of part-time workers, but to draw them into the insecure work, I think is a bit of a stretch. And in terms of labour hire, which I missed right at the top, there's about 3% of employees that are registered with a labour hire firm, and of those, about a third are paid by the agency. So it's important, I think, just by raising this to understand what are the real facts in terms of the debate. The fact that the casual numbers, apart from the effect of the pandemic last year, haven't really changed much over the last number of years, which says that employers, employ casual employers on an ongoing basis, depending on, and obviously depending on their work requirements. So what was removed from the bill? It's probably important just to cover this so you know, in terms of the context of the debate, which may come up sometime in the future. The bill proposed that 12 modern awards have essentially provisions which deal with part-time employees that can work additional hours at ordinary rates, and the employer can also give an employee flexible work directions or location directions to perform different duties on different work locations in response to the pandemic. And that was essentially designed to give those companies in those sectors covered by the 12 modern awards, essentially greater opportunity to essentially bring the business back up to the previous levels. That was obviously something which wasn't included in the bill. There were some proposed changes to enterprise bargaining. The most significant of which were proposed changes to the boot test to move away from a clause-by-clause assessment of agreements, which would have been, I think, a very good provision to include in the legislation. And of course, the termination of legacy or zombie agreements, which were made before the Fair Work Act commenced, or during the bridging period. So that would be the plan. The proposal was that they would automatically terminate by 1 July 2022. There's also some changes to the termination of agreements. Agreements couldn't be terminated until 3 months after the normal expiry date of an agreement, and there were some changes to pre-approval and approval processes. The Commission was required to approve agreements within 21 days, and also some pre-approval voting provisions which give employers the ability to determine how they were going to approve an agreement. There were proposed changes to greenfields agreements where major projects, there was maximum term, I should say, of a greenfield agreement for major projects would increase from 4 to 8 years, where a major project is one with a capital expenditure of either at least half a billion or $250 million. The other provisions which Labor say they supported were around compliance. There was a new criminal offence of dishonesty proposed, which where an employer engaged in a systematic pattern of underpaying employees, attracted a maximum penalty of 5.6 million for a corporation, 1.1 million, and 4 years imprisonment. Proposed general increases in penalties relating to remuneration-related conventions, which are essentially underpayments, including serious contraventions and sham contracting. The threshold for the small claim was to be increased to 50,000, and with provision for those small claims to be referred to the Fair Work Commission to conciliate or arbitrate by consent. What a significant change there. So if there was a small claim that was the matter could be referred on from the Federal Magistrates Court or the Federal Court to the Commission. So it could have been essentially a rise in small claims potentially there. So given where we're at with the changes to the legislation and those provisions that weren't included, so what should employers be doing, regardless of the fact that this legislation actually provides greater certainty for employers? I think employers should still be reviewing their casual arrangements. Now, what they should be doing firstly is reviewing terms in contracts, reviewing the fact that the payment of casual loadings, given that some of the provisions of the legislation are reliant on the fact that the offer of employment is that of a casual, and there's no fixed term commitment to ongoing employment, and the casual loading is definitely paid. Also, employers should be looking at processes to comply with the offer of conversion, and essentially that means that there's more onus on employers to ensure that you comply with the offer of a conversion based on the basis of the employee's hours and days, and two, the fact that you've advised the employee that they're not going to be offered conversion and the basis upon which you're advising that. As I've indicated, the provisions in the legislation are likely to be contentious with unions concerning casuals. So expect some claims in enterprise bargaining if you're bargaining over the next 12 to 18 months, 2 years. Whether these provisions, should there be a change in government, whether these provisions stay in the legislation remains to be seen. But I think that we've seen opposition from the Labor and the Greens. So expect that even if you do nothing and there's a change in government, first thing you should do is clearly look at your casual arrangements. But I'll be doing it now for those reasons, given the legislation specifically calls out some things that the definition of casuals are reliant upon. In terms of compliance, despite the removal of provisions around compliance, payroll compliance is a significant issue with employers. I think it's fair to say, had it not been for the pandemic, payroll compliance would have been probably the significant issue of 2020 for employers. As if you follow the press, there's a number of large companies that have self-reported to the Fair Work Ombudsman on underpayments, and the process there concerning self-reporting, you've got to essentially say to the Fair Work Ombudsman what you think the underpayment is. Generally involves an enforceable order from the court involving obviously restitution of those underpayments, but also the fact that they have to be audited by a third party, plus also apologies and then also some sort of contrition payments. So that's if you've followed the press, that's what's happening with a number of large employers. The Fair Work Ombudsman itself is increasingly well resourced, has significantly increased its prosecutions and the amount of wages recovered for employees over the last few years. So what should you be doing? So reviewing employee contracts for annualised salary arrangements, if you have them, to ensure compliance with modern awards. If you've followed the changes to modern awards, most or many modern awards were changed last year to contain annualised salary provisions. So if you've got award employees covered, then obviously it's important that you ensure compliance with those modern award provisions for annualised salary. I'll suggest also that you conduct regular wage audits, particularly when it comes to employees that are award covered and also award free and annualised salary, and ensure compliance with the Fair Work regulations. So Fair Work Ombudsman report last year, some of the main provisions where there's breaches, common breaches, are underpayment of hourly rates for weekend work, and also incorrect pay slips. So employers haven't got that right. It's also, I think, recording hours of work. So part of the provisions you should be looking at is, are we actually recording employees' start finish times and other things that which are required in the regulations. As I said, the Fair Work Ombudsman is increasingly well resourced. Its compliance and enforcement provisions are strengthened. It recovered in 2020, 123 million. That's a threefold increase from the previous year. In July 2020, there was more than 50 self-reports of non-compliance from large corporations that led to back payments of more than $90 million for 12,000 employees. And the audits, just over 1,400 workplaces in 2020. It's a non-compliance rate of 71% from those audits, which is very high. Most common preventions, hourly rate underpayments, pay slips, penalty rates on weekends. So common provisions which employers should be looking at, are we getting this right? And then in terms of litigations, which the Fair Work Ombudsman is doing, which is there's the litigations in 2020 were double that of 19. And then there's, as you say, there's a $4.3 million in court-ordered penalties. All right, so questions. Do we have questions? Ashley?
Hi, John. We have two questions. The first question is, what if the employee rejects the conversion offer and would prefer to remain as a casual? Is there an ongoing liability as an employer?
Yeah, so that's probably the most common question. So your first thing you do would say, if they've rejected the offer of conversion, first thing, I wouldn't necessarily accept that at face value. What you would do is go back and look at what were the terms of the engagement for that casual, in other words, a test in the act, and whether the person is paid, whether the casual loading is clearly defined. That's the second thing you do. And then what you're essentially doing then is relying on the provision in the legislation which go to the nature of employment of the casual. The fact that the employee, I would suggest you also would confirm in writing that the employee doesn't want the conversion. So they would be doing those three things if a casual employee refused conversion.
Our next question is, will there be an onus on the employer to offer the conversion to existing casuals, or will the onus be on the casual to request conversion?
The onus is on the employer to offer the conversion to existing casuals. So again, so you would, as I said at the start, it's quite an onerous provision for employers. So employers have got to obviously keep a record of their casual start dates, finish times. They should be putting in their employment processes the fact that they've got to look at offering and the fact that the casual is working regular hours and days, etc. They've got to look at offering that casual conversion, assuming that the work is going to be an ongoing and regular basis. Now, as I said, if you don't, if you decide you're not going to offer a casual conversion, then you've got to tell them why, and it's generally on reasonable business grounds, which is essentially around the ongoing nature of the employment, which is largely related to the ongoing hours of work and days that they're working.
Our next question is, how does the bill apply to outsourced casuals? I.e., we use labour hire for our casuals. What are the risks for our business?
Yeah, so that's largely related to the outsourced provider. So what do I say? What I mean by the labour hire employer. So there will be a requirement on the labour hire employer as the employer to actually ensure that they meet these requirements as well. So as the employer and not the employer of the labour hire, you should be clarifying that with the labour hire providers that they're meeting the requirements of the new provisions in the legislation.
Our next question is, can I confirm that if a Greenfields agreement is dated before 2009, that these will cease to exist by July 2022?
No.
And if so, what recommendations do you have?
So that provision in the legislation wasn't passed. So that means that those agreements made before the commencement of the Fair Work Act continue unless employers want to terminate the agreement, which there are provisions in the Fair Work Act around terminating those types of agreements, which require an application and other provisions. So if you need advice on that, I'd suggest you would probably want to talk to someone at Mapian to take you through the process.
Next question. Our casual employment contract states that the employee's hourly rate includes a loading. However, it doesn't specify the loading amount in dollars. Should we amend this?
Yeah, so first thing you would do would be to check that the loading the all-up rate is 25% above the rates of pay either in the award or that apply under an enterprise agreement. So if not, you would need to correct that. That's the first thing. And it's probably advisable for clarification to change the contract of employment to say something like that your all-up hourly rate includes a casual loading of the base rate of X and a casual loading of 25%. Something to that effect.
The next question is, if hours are seasonally impacted, would the regularity have to include these peaks, or would you base the part-time hours on the non-peak basis?
Well, the legislation talks about the last 6 months. So unless there's some other provision in your enterprise agreement or award, the legislation talks about the last 6 months. So you would probably glean that as to whether the employee works regular hours and days and that's ongoing. If it's seasonal work, then it's a judgment call as to how long the season is, whether it's a 3-month season or a 6-month season. That's dependent. So look, as a general rule, I'd suggest you would look at the timing of that work, but if the work for at least a 6-month period is regular and systematic and that's going to be ongoing, then I think you'd have to look at that. But given that the circumstances may be different based on the season, I'd suggest you probably look at taking specific advice on that from one of our team.
Next question, what happens where a casual has requested conversion, but their hours are not the same? For example, they work in daycare shifts, which are all over the place, but are working at least 3 to 4 days each week, but various hours. Can this be denied as the hours are not consistent? The employee has been advised they are not regular or systematic hours and not a minimum of 20 hours per week.
Okay. Well, what the legislation provides for is that where the employee works less than 38 and their hours are regular and systematic, that you would essentially look at the offer based on an assessment of the hours. In other words, you're probably looking at some sort of average. If it means the hours are really not consistent or systematic across the 12-month period or 6-month period, depending, then I think you probably should have a look at that, and I'd suggest take advice. But in a general sense, if you have effectively someone working less than 38, then you make the assessment based on what will essentially be an assessment of the average number of hours they might have been working effectively as a part-time employee, and those part-time hours would be the hours going forward. If the casual in this case is saying there's a work, depending on the nature of the work, they're working different shifts and different start times, morning, afternoon, nights. It's very haphazard. Then there's an argument to say that's genuine casual work. I'd suggest you take advice on that.
Our next question, if the employer reviews existing casual arrangements and determines that they do not meet the criteria for a casual, do we need to change to part-time, full-time, regardless of what the employee wants?
So is the question relating to a conversion, which I assume so? So it's bearing in mind the employer offers, bearing in mind if it's related to, say, for example, somebody working effectively part-time hours, and the offer then of employment is essentially that of a part-time, it's not whether the employee wants. The employer has the right to refuse. So the employer is required to offer. If, as I said, if the employer does nothing, then the employer, the casual has a residual right to apply for a conversion at some stage. If the employer offers and the employer refuses, and that, as I said earlier, that should be recorded in writing. I think that answers the question, Ashley.
Yeah, I think so. And the last question we currently have is, when does this come into effect? For example, if I have a casual employee who is currently at 11 months of service, who works regularly, am I required to offer conversion to them when they hit the 12-month mark in 1 month's time?
Yeah, so normal course of events, the legislation would come into law when it's actually receives assent, which is a normal course of events, and I haven't followed that up as to where that's up to, but I assume in a month's time that the legislation would become law. We will put out a brief note to say when the legislation is in law. But I think employers should assume the legislation is effective now and should be acting accordingly.
That was our last question.
All right. One of the other questions I was considering is, I've got someone who's a long-term casual, has worked for me for 15 years. As a casual, has worked regular hours, regular days. What should I do? The first thing is that you should be looking at offering the casual the conversion to permanent to full-time or part-time work, depending. Second thing you should be doing is checking the employee's contract to ensure that looking at the nature of the engagement, so the person is employed as a casual. You should also be checking the casual loading. In other words, you can apply the fact that the employee is paid a casual loading. In other words, the fact that you can apply the terms of the legislation to deal with claims for leave and public holidays, etc. So
we've received another question. It is, can employers reasonably and legally deny a conversion if there are any other mitigating circumstances? For example, the pandemic, a financial downturn, or a natural disaster?
yeah, so I think that you would look at reasonable business grounds. The Act has given some examples. So if, for example, in other words, a business is running at a level which is obviously as a result of the pandemic lower than it was prior to the pandemic, which means that you have limited options to offer the person permanent employment, then you would look at that and make an assessment. But the onus is on the employer to demonstrate the refusal to offer is reasonable. And if you've got any particular, in a general sense, if your hours are, because of the pandemic, the hours of the person employed is not certain, then, and that's because of it, you don't know what the business is going to be like in only on for 6 weeks' time because of the pandemic and ongoing outbreaks and shutdowns, for example. And I think that's you could argue that there's a reasonable business case there to say that you can't offer you conversion for those reasons. But I'd suggest you probably just run that past someone at Mapping and just take some specific advice on it. But in a general sense, that would be a logical argument.
We have another question. What if we have employees on current, regular, and systematic hours? It says dash full-time, so I assume it means equivalent to their full-time roster. We would like to offer them conversion, but on a different work pattern, i.e. a roster rather than straight full-time / 9-day fortnight. As the hours are going to be different, same number but different pattern, is there any risk in us doing this?
It's open to offer those hours without the conversion, so you could offer it anyway. So I think the legislation talks about where the work is regular and systematic. So it doesn't necessarily say there's got to be the same. So it's got to be the same hours. So the offer, it's an offer of full-time employment based on the hours that the employer was working. So if it's full-time hours, it's full-time hours. Now, and what employers point to was the fact that, well, the hours that these casuals are working are varied and may go up and down, and the shifts may stop based on the business requirements. But however, if you're offering somebody a permanent conversion, and then the hours which are more essentially around different hours, but they're more permanent. In other words, you can offer them that way. Then that's arguably a reasonable position to put to employees. They might. So I think that's something which I think you should obviously communicate to employees. There's nothing, as I said, there's nothing stopping you doing that now anyway. Sorry, we just got a fire engine here. Anyway.
We don't have any other questions.
All right. Okay. So one of the other things question I was thinking of is what to do where we have a casual employee with an all-up rate, but the casual rate is not. The casual rate isn't defined. Well, what I'd be doing as an employer would be essentially ensuring that the all-up rate has, as I said earlier, has some reference to either casual loading of 25% as a separate amount, or the amount is 25%, which is inclusive in the all-up hourly rate. And that was one of the issues with scheme, that whilst the employer was defined as a casual and paid a casual and paid up all-up rate, the casual loading wasn't defined, wasn't distinguished as a certain amount. That was the other point in scheme. Okay. I don't think there's any other questions. Any other questions, Ashley?
No.
All right. Well, given that there's no other questions, once I said what we'll do once the confirm the legislation is law, but I'd suggest employers operate on the basis that it is. Then we'll advise clients. Again, employers should be tasked with doing those things that we've set out in the presentation, particularly around casuals, specifying their nature of their employment. Also, the fact that they're paid a casual loading, and that's specifically stated somewhere. Looking at compliance issues, even though taking some initiative on that, we can assist the businesses with all of those tasks and undertakings. So if businesses needed some assistance on any of those sort of things, then they should contact someone at one of our offices in Brisbane, Perth, Sydney or Melbourne. So yeah, and any other questions concerning employment matters generally, then feel free to contact the business. So thank you for your time. Thank you, Ashley. And we hope you have hope you have a good day for the rest of the day. Thanks.